Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. My guest is attorney Linda Resnowicki, and she is an expert on landlord-tenant law, and she represents most of her practice is limited to landlord-tenant law. And today we're going to focus on the question of residential leases. And Linda, thank you for coming on Law You Should Know. And
thank you, Mr. Landau.
And why are leases so important?
Well, leases describe the relationship between landlord and tenant, or try to. They set forth the term of the lease, the beginning, the start date, and the end date, the rental amount. They give tenant the right to exclusive possession. They identify the tenant and the landlord. They describe the lease premises, and of course, both parties signed. So both parties bind themselves by the lease.
In effect, it's like a contract between the landlord and the tenant.
Absolutely, a contract.
And describing the rights and responsibilities of each party.
Maybe, yes, it describes the rights and responsibilities, but the description in the lease may not be accurate. So reference has to be made to New York State law, statutes, and case law. Right,
so those laws or statutes or case law may control regardless of what the lease says.
That's right.
And sometimes, there might be a standard lease, or the landlord or the tenant can customize it or add in terms that are important to them that are agreed to by both parties.
Right. There's Real Estate Board of New York, Julius Blumberg, Rent Stabilization Association. All of these organizations provide form leases, and where people like me come in, where attorneys come in, we draft riders primarily for owners and landlords, and we review them for tenants.
But if a tenant is of sufficient means and they have concerns, they might want to pay an attorney to review the lease.
Absolutely. The lease is supposed to be written in plain, understandable language, clear, and in a certain, more than 8-point type. And so a tenant should be able to read it. But if there's something that a tenant does not understand, it would be appropriate to come quickly to an attorney to get an explanation before signing the lease.
And especially if there's a lot of money involved, or the landlord has made certain promises, and the tenant wants to make sure they are adequately incorporated into the lease. Again, they may want to have it reviewed by an attorney.
That's right. If it's not in the lease, it doesn't exist.
Even if it was verbally promised. So
verbal promises do not exist, and the lease does state usually that it's the entire agreement between the parties.
Right. So I know there's a lot of different little things about leases you want to review. So let's start with the term of the lease. Some of the things that are usually contained in every lease. So let's start with the term and the rental amount.
The term and the rental amount, well, in market leases, not rent stabilized or rent controlled, that is subject to negotiation between the parties. The landlord will generally make a demand for a rental amount, and the tenant will either meet it or go to the next landlord and see what other properties are available and at what price. So the term is usually, a landlord will usually give a new tenant a term of 1 year. The rent stabilization law, for example, gives tenants the option of picking a 1-year or a 2-year lease.
Okay, and I know we have a lot to cover. So again, with the term, the lease will also describe the premises. So if the tenant is going to have access to storage, to a yard, to laundry, or other things, they really should also be mentioned in the lease.
Absolutely.
And the lease, as you mentioned, it should be written. If there's anything that a verbal lease would be appropriate for?
If a lease is under a term of 1 year, say a month-to-month lease, it does not have to be written. But writing always clarifies any misunderstanding that might exist between the parties. So I've seen written month-to-month leases also.
Okay, and what about checking out in terms of best practices? You mentioned the rider to a lease. So what might the riders deal with?
The riders, there are many provisions that could be contained in a rider. For instance, let's see, a landlord could provide that a tenant is not allowed to smoke cigarettes or any other substance in the subject premises, and that would be a legal provision. A rider might provide that a tenant is not allowed to light candles in the subject premises, is not allowed to leave if the tenant has a front yard that the tenant could use. Possibly there would be in the rider a designation that they should not leave their outdoor furniture in the front yard. Anything you can imagine could be included in a rider. But of course, if it's something illegal, like we promise not to have children while we live here, that would be an absolutely illegal provision in a rider.
Can it limit the number of people to occupy, or related or non-related?
That's a very excellent question. Many leases, the form leases say tenant and only tenant may occupy this apartment. But the reality is that tenants, immediate family members, plus an unrelated person can occupy the apartment. In New York City and other places, I'm sure as well, there are occupancy limitations. These occupancy limitations are set forth in the New York City Housing Maintenance Code, the Administrative Code Section 27, and it says that there should be 80 square feet available for every person occupying an apartment. So, subject to and limited by overcrowding provisions, a tenant could have immediate family members and an unrelated roommate occupying.
Linda, I just want to move along because I know there's many important points, a lot of information you have to give. In terms of rider, can we also discuss whether pets are allowed?
Oh, yes, and that is a large subject that will take an entire program, but it's usually in the form lease that you will find the phrase, no pets allowed. Now, that is subject to the law, and it could be that if you have a disabled person, a blind person, well, obviously that person could have their guide dog, but more recently you have persons who suffer from depression who might have a doctor's note, and they are entitled to have a comfort animal.
Right. So there might be laws that override the lease. But and let me just ask you a couple. Can a rider also prohibit a business from being conducted, or let's say ban the playing of music at certain hours?
Absolutely ban the playing of music at certain hours. That would be an excellent provision in a rider. In terms of conducting a business at the premises, in New York City, for example, under the zoning resolution, one is allowed to use 25% of the apartment or no more than 500 square feet for what's called a home occupation.
But
in other words,
can a landlord ban it even if it's allowed by zoning laws?
No,
okay.
The law would override the lease.
Fine. And what about use of an apartment for Airbnb?
Oh, that's absolutely prohibited under New York City law. That is in fact subletting. Subletting could be done with the consent of the landlord if it's for, a period of more than 1 month. But
so the landlord in a rider could ban the use for B&B, Airbnb, or could permit it if it was part of the contract between the tenant and the landlord.
Well, it could be permitted, but in New York City, Airbnb, I do believe, is not legal at this time.
Okay. And let's talk about some of the other things. What about security deposit?
Oh, security deposits, a lease will definitely provide very rarely will not provide for the provision of the security deposit. The security deposit is often equal to 1 month's rent, could be equal to 2 months' rent, and the landlord is required to keep it separately from landlord's funds. The landlord is allowed to charge a 1% administrative fee for holding a security deposit, which would leave tenant with very little money upon departure, really, in terms of interest. The security deposit does not have to be placed in an interest-bearing account unless the apartment is 6 units or more. So it could just be placed in a separate account, and the tenant must be notified of what bank and what the bank's branch address is regarding where the money is kept.
Right, and the security deposit's mainly to guard against damage by the tenant to the premises.
That's true, and to secure the tenant's performance of the terms of the lease, including, for instance, the payment of rent. So if tenant does not pay the last month's rent and leaves the apartment in undamaged condition, that security deposit could be kept. However, tenants are often under the misimpression that they are not obligated to pay the last month's rent because the security deposit will cover it. That's not the purpose of the security deposit. As you said, it could also be applied to cover landlord's damages.
So the tenant really doesn't have the right to say, use my security as last month's rent, and the landlord doesn't really have the right to take it as the last month's rent.
Well, the landlord could take it as the last month's rent if tenant doesn't pay the last month.
Right.
Yeah.
And what does the lease have to be delivered once it's signed by both parties? Or
absolutely. If it's not delivered, it's not enforceable against the person who did not receive it.
Okay, we're going to take a short break, and when we come back, we'll continue our discussion with attorney Linda Resnowicki about residential leases, and she also has a website, landlordtenantlaw.net, which gives more information about landlord tenant law and residential leases. And she also has offices where she concentrates in the practice of landlord tenant law in Manhattan. You are listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
WHPC 90.3, the radio voice of Nassau Community College, is looking for individuals, businesses, charities, or organizations in our local and global community that would like to donate to support our radio station. Whether you listen locally or online, here is how it works. Go to our webpage at ncc.edu/WHPC and click Donate Now. Or if you prefer, you can send a check to WHPC Radio, 1 Education Drive, Garden City, New York, 11530. Make check payable to the NCC Foundation. In the memo of your check, write WHPC Donate Now. Any contributions will help defray our operating costs, and it's tax deductible. This message was brought to you by the radio voice of Nassau Community College. Streaming online at ncc.edu/WHPC.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking with attorney Linda Resnowicki, and she's an attorney with offices in Manhattan concentrating in the area of landlord and tenant law. And she also has a website, landlordtenantlaw.net, which has additional valuable information. Linda, you were telling us about some of the dealings between landlords and tenants, some things that landlord and tenants cannot do, and some of the terms of a residential lease. I just want to take a step back, and sometimes landlords require tenants